Dear students, GPS CLAT Academy at Gyanodaya, a senior secondary school at Sikar, supports its students in their CLAT preparation. We have started a lecture series which will be delivered to you on a daily basis on YouTube. The lecture series revolves around discussion of mock papers. You can request us for the concerned mock papers.
What are the issues of significance in this? If we know earlier the temple, there are historical evidences which show that the temple was established by Buddhists first, and then during the medieval ages, during historical ages, the pre this during the ancient period of history. This period starts from anywhere uh, before the birth of Christ and ends till the start of the medieval period. And medieval period basically starts from the Indian history starts from the arrival of the Turkish invasions, then the Mughal invasion of India, right? And up to Bakhtiyar Khalji's invasion of India, the the Buddhists were in control of the shrine, but later on some enterprising person from Hindu community established the Bodh Gaya Mutt, and then there has been a tussle between the Buddhists and the Hindus. The Buddhists have been claiming that look, this is one of the most sacred sites for Buddhism, and therefore the control should go to them. Whereas on the other hand, the Hindus contest that look, we have also been associated historically with the site, therefore we would not like to lose control. Now, this is a controversy which calls into question Article 13, Article 25, Article 26, and Article 29 of the Constitution. Vis-a-vis, the same rights are available for the majority community as well under Article 19. Right? So, Article 19, Article 21, Article 14, all these. So the court has to do a balancing act. The petition, in the petition, that a balancing act has to be done, and basically the bone of contention comes on 2 points to which faith the tipping vote in the conference and the 8-member management committee is of the chairperson because he belongs to the Hindu faith. So 4 and 1 makes it 5, and 5 means Hindu majority. Buddhists have a problem with it. So this is a contested domain, and this is how rights balancing a complex work has to be done by the courts. Not an easy task to resolve this ticklish issue. All right, let us come to the questions. The first question is question number 90, which has been answered in the correct by everyone, so we will not take it up. Second question is question number 91. The Union government issues orders under section 79 of that. This is number 1. So question number 84 has been marked correct by everyone, so we are not interested in this. Then you have question number 85. Question number 85, basically, yes, this is marked correct by only one student, so we'll take it up. Bodh Gaya Temple Act PTA 1949 has been challenged by Buddhist monks who argue that it violates their constitutional rights. Based on your reading of the passage, which articles of the Constitution can the petitioners claim to have been violated? So, reading of the passage, which articles of the Constitution can the petitioners claim to have been violated? Now, why do you say that it is only 2, 3, 4? Why not Article 13? What is Article 13 talking about? Article 13 says what is a state, right? Article 12 says what is a state, and Article 13 basically says, I'll just share it for yourself. What is Article 13 talking about? So all laws enforced in the territory of India immediately before the commencement of this constitution, insofar as they are inconsistent with the provisions of this part, shall to the extent of inconsistency be void. So this article is in question. Then second one is the state shall not make any law which takes away or abridges the rights conferred by this part. And any law made in contravention of this clause shall to the extent of contravention be void. So Article 1 is in question here, and Article 2 is not in question here. Article 2 is not in question here because it puts a prohibition on the state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall to the extent of contravention be void. So this article basically, this Article 13 and clause 2 basically applies to post-constitutional laws. After the constitution came into force in the year 1950, it applies to those parts. But Article 1, Article 13 clause 1 applies to all laws in force in the territory of India immediately before commencement of this constitution. So Article 13 clause 1 is talking about all those laws which were immediately in force before this commencement of this one, insofar as they are inconsistent with the provisions of this part, shall to the extent of inconsistency be void. So if the law is in force and the law has been continuing since from a time since I mean law has been continuing in force from a time prior to commencement of the constitution, then that law also shall to the extent of contravention be set aside or void. And then in Article 13 clause 2, there is an express prohibition on the court not to make any law which is in contravention of the provisions of this part, which is the fundamental rights part. So this is where the situation stands. Now the rights are being contested. This is a pre-constitutional law. They say that pre-constitutional law violates by redrawing the composition of the management committee. It basically violates our constitutional rights. And which are the rights which are being violated? Article 25. What is Article 25 talking about? Can you tell me? You must have read it in your constitution at work. If you have seen that, then what is Article 25 talking about? So subject to public order, morality and health, and to other provisions of this part, all persons shall be equally entitled to freedom of conscience and right freely to profess, practice and propagate religion. Very clear. Subject to public order, morality and health, and to other provisions of this part, all persons, this part means part 4, fundamental rights. All persons are equally subject to freedom of conscience and right freely to practice, propagate and religion. To which community is the benefit going under this article? It seems the benefit is all persons. So whether you are minority, whether you are majority, all are equally entitled to practice and propagate, profess, practice and propagate their religion. So this is another article which requires a complex balancing. What can be regulated? Essential religious practices may not be regulated. For example, clause 2, nothing in this article shall affect the operation of any existing law or prevent the state from making any law regulating or restricting any economic, financial, political or secular activity which may be associated with religious practice. So what is the ambit of the right which has been given? And the right is the right to practice, profess and propagate religion. They are saying that insofar as the right to practice, profess and propagate religion can be divorced from the secular aspects of religion, of practice of religion, economic aspects, financial aspects, political aspects. The secular aspect could be appointment of the priest. Government will come out with norms that the priest will be appointed provided he has the following qualifications: he knows the Vedas, he knows the relevant scriptures, he holds the knowledge of those essential traditions of which constitute the essential tenets of that faith. He is well versed with all that. So those aspects can be regulated, right? But essential religious practices cannot be regulated. And what are those essential religious practices? For example, even if it amounts to superstition, it makes no difference. If it is a essential religious practice, then it cannot be regulated. But only essential religious practice propagate and um, propagate and uh, practice religion, practice and propagate religion. Only to that extent the activities are religious. To that extent, your right is there. But with respect to all other secular activities, political activities, financial activities, economic activities, the government has the right to carry out the regulation as per the law. And for social welfare, for example, abolition of the practice of untouchability in the temples, for example, the Sabrimala temple, in which the Supreme Court gave a ruling that women are allowed to enter. Likewise, in other places, and going back in the during the times of freedom struggle also, when there were temple entry movements, all those are also exempted from the purview of essential religious practice. They will not be counted into essential religious practice. Social welfare, Hindu religious institutions of public character to all classes of Hindus, and all those, nobody can have an objection to all that. So basically, this is the article within which the the government has to exercise its power. Next article in which you have to exercise, the government has to exercise its power is Article 26 of the Constitution. What is Article 26 of the Constitution talking about? You must have gone through all this in your uh, in your class on constitution at work, but I don't know how much of it you will recall. But it is important that you recall, because these are essential articles. This is also knowledge of polity. So you will be expected to know all this. And in the study material which I have earmarked for you, in that all these articles are there. Sometimes it is more convenient to actually read the entire article instead of seeing one two lines in the study material. Sometimes when you read something which is longer, then you tend to remember things for a longer period of time. So this is why I'm taking pains to explain to you that these are the articles you have to read. Please read these articles. Whichever articles I'm referring to in the class, they are automatically important. What is the essence, that what in essence are the principles which are contained in the articles? They are helpful to you in tackling any question which comes based on a passage extracted from the field of Indian politics. Right. Now, please come to Article 26. I have done a screen share of the same. Subject to public order, health, and morality. So, if any question comes, then there is a rider subject to public health, morality, and morality, public order, health. So, be very what we call as be alert that there may be something in the question based on this itself, because legal terms on very critical aspects, it is like the big picture may never be called into question, but it turns on certain critical aspects every time. Subject to public order, morality, and health, every religious denomination of any section, whether religious denomination or any section thereof, shall have the right to establish, maintain, and manage religious services for religious and charitable purposes. This is the right under which the monks are agitating. That we have a right subject to public health. So the Buddhist minority falls under this. This, if you are a denomination or you are a section of the denomination, if you are a minority community religion, then this is where your freedom of religion comes in. Now here we have a majority community, Hindu community, and you have a Buddhist minority. Buddhists are minority in India, even on the national scale, and even in the state-wise also they are a minority. So to manage its own affairs in matters of religion. So this is where they come, that we have a right under the constitution to manage our own affairs in matters of religion. And when you put a Hindu magistrate there, then our majority is not there. It is the majority most of the times of the Hindu community. Therefore, what happens of our constitutional rights? That is what they are agitating for. To own and acquire immovable and immovable property, that is also our right. But here, what they are saying is to manage our own affairs in matters of religion. That this Hindu majority, Hindu interference is basically causing us a lot of problem. and we are not in a position to exercise our fundamental rights. These are all in the in the part 3 of the Constitution, which is the fundamental rights. Part 4 of the Constitution is of the directive principles of state policy to administer such property in accordance with law. So, to manage affairs, then there is another article which is called into question, and that is Article 29 of the Constitution. Article 29 of the Constitution, what is it saying? 29 and Article 30 of the Constitution, what is it saying? I'll just have a brief reference to that also. Article 29 of the Constitution also I'll refer to. I'll just refresh your memory so that Article 29 says, I'm sure you will be able to see on the screen also. Any section of citizens residing in the territory of India or any part thereof, having a distinct language, script, or culture of its own, shall have the right to conserve the same. So this is clear. No citizen shall be denied admission. This is admission specific. But here, a distinct language, script, or culture shall have the right to conserve the same. Now, here, what is being asserted? Culture is being asserted. That our Buddhist culture is very broad term, and it includes your religiosity, the way of life, and all that will be included. It is an all-encompassing term which talks about your culture, that we have a right to conserve our culture. So we have a fine balancing act here. On the one hand is a Buddhist minority, which talks about asserts their constitutional rights. On the other hand, there is an equally assertive Hindu majority, which says that this institution is important for us historically, because we have also been associated with the coming up of this institution, and the institution is in its present shape because we took up the cudgels, and we brought up the mutt in the present shape. So this is the complex balancing act which is involved. These are basically the articles which confer these rights. Article 29 comes into question because it is a matter of preservation or conservation of culture of a minority institution. Article 26 comes to concern because once again it is the question of preservation or management of the rights of a religious denomination, and Buddhist minority religious denomination. Article 25 comes into question because Article 25 is a guarantee which has been afforded to all, whether they are minority or whether they are majority, irrespective of which community to which you belong. All have the right to practice, profess, and propagate religion throughout the length and breadth of the country. So this is the complex. This is the legal matrix or constitutional matrix within which the rights are being asserted. And of course, there is Article 13 of the Constitution, which has actually got two clauses. One clause is with respect to pre-constitutional rights, and another clause is with respect to post-constitutional rights. The clause with respect to pre-constitutional laws basically provides that if the laws continue to be to contravene the rights conferred by Part 3, the Fundamental Rights chapter of the Constitution, then they shall be void. And those rights of which and that is subject to from the commencement of the Constitution. Just to refer to it once again, Article 13 of the Constitution. They are saying from the commencement of the Constitution, it is talking about. This is what it says. Once again, I'll do the screen sharing. All laws in force in the territory of India immediately before the commencement of this Constitution, insofar as they are inconsistent with the provisions of this part, there seems to be a typographical error. It is pen, it is actually part. Shall to the extent of inconsistency be void. So all laws in the force of territory of India immediately before the commencement of this Constitution, insofar as they are inconsistent with the provisions of this part, shall to the extent of inconsistency be void. So they will be void if they are inconsistent with the provisions of this part. They will be void from when? They will be void from the date the Constitution takes effect. That is, from the date in 1950 when the Constitution was implemented. Right? From that date, all the laws which were in force in the territory of India, that is, which were there in the British India in colonial times, all those laws which are found to be in contravention of Part 3 of the Constitution, then those laws, to the extent of the contravention, shall be void. So what happens of those laws which are not void? They will continue, and those parts of those laws which are found in contravention of the Constitution shall be void. It is very clear. Then those laws which, and then there is a prohibition followed in the Article 13 Clause 2, that you shall not make a law which shall be contravening the provisions of this Constitution henceforth in future. Therefore, Clause 2 provides for post-constitutional laws, and Clause 1 provides for pre-constitutional laws. So this is the constitutional matrix which you are already aware about in your political science working of the Constitution. And read up once again your NCERT that contains chapter 2 or chapter 3. I don't know which chapter, but there is this thing. Plus, just type Google that Article 13, Article 14, Article 15. Have the entire text of the Constitution in front of you. Nothing wrong with that. You can read it with the abridged version given in the NCERT also. And at various places in the Constitution, the full version is also given. So if you read this with that and try to assimilate the basics, it will help you in solving your legal reasoning questions. Because familiarity gives speed. If the familiarity is not there, then you will take more time, and we don't have any time, right? So now let us. So all these articles, 13, 25, 26, 29, all these articles touch upon the rights of the parties in this case. That's why 1, 2, 3, 4 has been given as the petitioner's rights have been violated, and the violations will be considered under these articles, right? As per this. Now, please come to question number 86. In the light of 2013 amendment to the Bodh Gaya Temple Act 1949, which aimed to address concerns over temple's management structure, the Supreme Court is reviewing a writ petition filed in 2012 by Buddhist organizations seeking the repeal of the act. What is the most likely action the Apex Court would take on the petition? Now, the Supreme Court will declare the petition moot, infructuous, as legislative amendment addresses the. But then there may be other aspects, right? The legislative amendment basically seeks to provide. They have made it 50-50. I mean, they have put the collector may be of any faith, the district magistrate may be of any faith, but their argument is that he may not. Most of the time, he will be of the majority faith only. So it is a majoritarian management committee which we are facing. It is actually equal only in a very, very unacceptable way. Supreme Court will proceed to hear the petition as the amendment did not grant full control of temple to the Buddhists. Now, this we can't say because what the Supreme Court will do and what the Supreme Court won't do. This we can't say for sure that this is what they are going to do, because so many articles are concerned, interpretations of so many articles are concerned. Then the Supreme Court will dismiss the petition provided other issues, if any, are sufficiently addressed. So in this case, the government has provided that there are two facts that are competing. One is the control of the Hindu community, which is because this is an institution established by them also. On the other hand, in the Buddhist community, this is Article 25 gives rights to both of them, both the Buddhist minority and the Hindu majority, that you have a right to practice, profess and propagate your religion. Both of them have the rights. Both of them have the riders subject to which they can exercise their rights. And those riders are public order, morality, and health. Those are the riders that apply to all of them. And at the same time, you have Articles 26 and 29, which basically provide additional protection to minorities, just to make sure that majorities don't ride roughshod over the rights of the minority communities. So they have taken the care to make sure that whenever minority community rights are involved, then the contest doesn't become majoritarian. It has to be on the fair principles enshrined in the Constitution. So this is how the balancing has to be done. Nevertheless, since both the communities have a right, and both the communities have been historically associated in establishment of the temple, therefore both the communities, neither community can be ousted from practice, propagation, and and profession of their rights under guaranteed under Article 25. At the same time, there are additional guarantees under Article 26 and Article 29 of the Constitution in favor of minorities. But those additional guarantees cannot really trump the rights, general rights which have been given to both the communities under Article 25. So it is a complex balancing act. The answer does not appear to be so obvious to us. Now, in this constitutional matrix, if we take that the state government has indicated a solution that the district magistrate may be of any faith. If there are other issues that are there, they have to be gone into. They have to be addressed by the Supreme Court. Otherwise, the Supreme Court will say that now the amendments have addressed the complicated issue, and therefore we will declare the petition as infructuous. Then there is the last one. The Supreme Court will direct the petitioners to engage with administrative remedies under the that is like saying that you go and take your claim elsewhere. We don't have the time to decide it. That is not an appropriate course of action. Supreme Court doesn't have the jurisdiction to say all that, and it will never say that unless there is a mistake. Now I come to question number. These I am not touching. These I am not touching. I come to the next fact situation, which is basically legal reasoning. Question number 90, and the passage is 16, 16. So quickly go through the passage and tell me what is there.
So this passage talks about a recent dispute between Elon Musk company X and Indian government. And in this passage, it says that the Elon Musk company X has filed a case in the Karnataka High Court against the Indian government. And X says that the government is unfairly using Section 79 of the IT Act to block content and instead of the proper Section 69A, uh, which has the Supreme Court approved safeguards. They are using Section 69 of the IT Act, and X is also against the new SIOG portal, and this SIOG portal allows even local police to send content blocking orders, and X call this portal a way to censor content without proper rules. And the government says that they are not a direct blocking order, but they are just alerts to remove illegal content. And if X doesn't remove it, they can be held responsible for it. And X has asked the court for protection, and they have raised concern about they have raised concern that they might face legal action if they doesn't follow these new orders, and the court will hear the case again on March 27. That's all from my side.
Yes.
So the passage talks about the Elon Musk company X Corp
Yes.
has moved the Karnataka High Court challenging the government approach to the blocking content on its platform. The company is also opposing the center Sayok portal is censorship portal and allow the government agency and local police to issue the blocking order. And the X Corp argue that content blocking should only be done under the Section 69A of IT Act, which has Supreme Court mandate safeguard. And the government is using the section 79 clause 3b to notify the platform about the illegal content, making them liable if they don't remove it. And they launched by the Ministry of Home Affairs to automate the blocking order, and also Xcorp called it a censorship portal, arguing that it delegates the power unlawfully to agency that MIT itself does not have under the IT Act.
Yes.
And the X Corp seek interim protection, fearing the coercive action if does not comply with the Sahyog
Yes.
portal order. And the court adjourned the case on March, allowing X to file the petition in any action is taken against it.
Mm. Yes.
And X Corp argued that the government expanded blocking power violates this legal safeguard, while the government insists the local agency need authority to regulate the online content.
Yes.
And the Karnataka High Court decision on March 27 could have major implications for digital censorship and free speech in India.
Yes.
That's all.
Yes.
So this article basically talks about the legal battle between the government of India and the formerly Twitter, now X Corp. So what's happening is that the uh, X Corp is alleging that the government of India is uh, using Section 79 uh, to force content removals without following a legal process that was set by Supreme Court. However, the government says that these are not censorship orders, but just liability notices. So, what's happening is that Section 69A is basically where the government can issue notices to individuals such as X Corp in this case to block certain content in their platform. Now, the intermediaries may not be held liable. This is basically a safe harbor for them. Whatever content may be posted on them, if they remove it, then they are safe from whatever content violations that may have been caused. However, if they do not remove the content, they may be liable under Section 79B, where the intermediary can be held liable, meaning they are not in a safe harbor, and therefore the government can issue a blocking order without any hearing from a committee or court. They can simply issue a blocking order against the platform in question.
Yes.
Now, what XCOP is urging is that the government is misusing its power to engage in backdoor censorship, which is not fair. However, the government has said that we are not a simple censorship orders, just liability notices, and the platform in question are free to act or not. The main concept that we see in the passage is basically how far the government can go in policing online speech, whether it's lawful or fair.
Yes. Yes. Basically, this article, the facts are very well known to you. And the legal principle which comes out of this article is based basically on the doctrine of colorable legislation. And what is that doctrine of colorable legislation? Doctrine of colorable legislation says that, and I'll share it with you. A very brief write-up on what exactly is the doctrine of colorable legislation, and you'll be able to see on your screens also. Doctrine of colorable legislation is a legal principle that is used in constitutional law to determine the validity of laws enacted by a legislative body. So, what is the legislative body? The parliament. Right? So, whether the laws which have been enacted by the parliament are, or for that matter, by the state legislature, are constitutionally valid or they are invalid, is determined by reference to the doctrine of colorable legislation. Now, there have not been many judgments which which have overruled, resulted into um, which have resulted into setting aside of the laws enacted by the parliament or the state legislatures using this doctrine. There have been only a few instances when this power has been used. And what is this power? Suppose there is an entry in the constitution. There is an entry uh, in the state list. State list. You must have asked. You must be knowing about the state list. There is an entry in the state list, right? And that is the list two, state list, right? State list is list two, and that state list basically provides that in the Article 246, if you read Article 246 of the Constitution, along with the entries which are there in the state list, then the state government has the power to make laws on those items, right? Now, I will show you Article 246 also. I will share the article with you. Just give me one moment. Article 246 of the Indian Constitution is important in this regard. And just do a small share of Article 246. And what is it talking about? This is where from the discussion is coming. And this is what the article which has, this is what the legal argument which has been posted in this case is basically proceeding from this. You see, Article 246, subject matter of laws made by Parliament and legislature of states. So Article 246 provides what laws could be made by the legislature of the state and what laws could be made by the Parliament. And it is saying that notwithstanding anything in 2 and 3, Parliament has exclusive power to make laws with respect to any and matters enumerated in list 1. So in the list 1, the Parliament makes the law. That is already clear to you from your 8th class itself, that there are 3 lists in the Constitution, that the Parliament has the power to make laws in the list 1. Then in the list 2, the state government has the power to make laws. And then in list 3, you have both of them have the concurrent power to make laws. Now these are already clear to you from a very early time, and this is that article provides the same thing in a little bit more elaborate form. Now what happens is that the the lists are there in the Constitution. Suppose I share the lists in the Constitution. You must have seen them also. In the seventh schedule of the Constitution, you have the lists, the 3 lists which are there. So I'll share those 3 lists also with you, and you'll be able to know what I'm talking about. Um, so just give me 1 second. Let me show a list to you. This is yes, on schedule. Yeah, yes, here it is. Now share this tab. Now you can see, I'm sure, the concurrent list, criminal law. So criminal law is a matter of state list. Sorry, concurrent list. That is both central and state government will have concurrent powers. Criminal procedure, concurrent powers. Preventive detention, concurrent powers. Removal of state from one prison to another, and so on and so forth. There are so many of them, right? Which are there in the concurrent list. Now, please come to the matters which are enumerated in the 7th schedule of the Constitution, which is actually the state list. This is the list 2, 7th schedule. Public order. Public order, not including use of any naval, military, air force. That is because they are covered in the first list. So they are covered here. They are excluded here. Police is there in the list 2. Officers and servants of High Court. These are in the list 2. Prisons and all that. Local government. Public health, sanitation. So all those issues which are of relevance to the states have been kept in the list 2. Because these are all very local in their scope. There is nothing national about them. Or there is nothing like, you know, across several states they apply. They don't. So those are local to the state. So interstate matters are not there. Here in the list 1, you have interstate matters. All interstate matters or matters which pertain to the nation as a whole. Here is defense of India. Then naval, military, and air forces, which was excluded, there is included here. Then deployment of armed forces, delimitation of cantonment areas, naval, military, and air force works, firearms, ammunition, explosives, atomic energy, industries declared by Parliament to be necessary, CBI investigation, preventive detention for connected with defense, foreign affairs, security of India, then diplomatic consular, then United Nations organization. So you can see those which are concerning the nation as a whole are populated in the list 3, and those which are not there they don't concern the nation as a whole, they are populated in list 2, and where both of them have concurrent powers, they are listed in the list 3. So we have 3 lists in the Constitution. The governing article on those 3 lists is Article 246, and Article 246 has to be read with list 1, list 2, or list 3, right? This is what is there in the legislative power. So now the question arises sometimes in the legal parlance that if there is an entry in the suppose there is an entry in the union list, right, and the state government takes an action on that, legislative action on that, the state legislature takes a legislative action, that's like a law on that point, which is in the union list, but actually it purports to take action only on a matter which is there in the state list. Can you imagine a situation where this can happen? This is possible. I mean, for example, if I say that agriculture, including agricultural education, research, protection, pests, prevention of plant diseases, and so on and so forth, right? This is a matter included in the state list. But there may be an aspect of agriculture which is included in the union list, right? All right. Now, please come to this 18, land. That is to this right over land tenants, including relation of landlord and tenant, collection of rents, transfer and alienation of agricultural land improvement and agricultural loans, colonization. So you say land is a subject under 18, and there may be a subject in the union list also pertaining to land. Can we locate that? Just let us try if there is a subject which is there in the union list also which pertains to lands. Let us quickly run through this. If you notice, please let me also know. It is perfectly possible that it may find it's mentioned here also, and it may find the mention there also, right? Now you see, property of the union. Now you see, property of the union. Now land is in the state list, but here is property of the union. Where will be the property of the union situate? Union does not exist. It is states which exist. Union is the superstructure, which cuts across the entire nation. It is the state which is actually the demarcating boundaries are demarcated for the states. Therefore, entire land of the union is parceled out among the states. So, land and property of the union, there is a likely clash between the two. So, you can imagine a situation where actually they are legislating on the land which is their state subject, but they end up legislating on property of the union. So, what is it happening? While purporting to exercise power on a matter which is within their legislative domain, the state government has actually exercised power with respect to a matter for which the power is reserved to the union government or union legislature, I should say, the parliament, because we are talking about legislative powers. We are a parliamentary system of government, and parliamentary system of government, it is the legislature which makes the law, and it is not the government which makes the law. Although the legislature is or legislature has an overlap with the government in the parliamentary system of governance because of the requirement of numbers, right? So we say that there is an overlap between the two. While the state was enacting a law within its own field, actually it transgressed on the power which is reserved for the union. So this would be called colorable legislation, colorable use of the power to legislate. Because while purporting to lay down a law for the state, the state legislature ended up making a law for the union government, right? So this is called the doctrine of colorable legislation. When purportedly you are exercising power within your domain, but actually you are exercising power outside your domain, right? So this is the legal principle used in constitutional law to determine the validity of laws enacted by legislative body. Doctrine suggests that if a legislative body, while staying within its legal powers, enacts a law for a specific purpose but is not true or stated purpose, it can consider colorable exercise of power. So that is a colorable exercise of power while enacting on its own sphere of jurisdiction within its own jurisdiction. It has actually ended up usurping on the jurisdiction of the union. That is a colorable exercise of power. Sometimes there is yet another interpretation which is there. That is the doctrine of pith and substance. That is also a related constitutional doctrine, and questions can come from that also. Questions can also come on doctrine of eclipse. There are several contexts in which, as and when the context arise, I'll explain you that. I will not jumble up all those here only. Here there is an argument which has been set up by the on behalf of the petitioner, that look, there is a colorable exercise of power. So what exactly is the connotation? What exactly is the context in which the argument is being used? There's a colorable. He is not saying colorable exercise of legislative power. He is saying colorable exercise of executive power. So he's talking about. He's using that argument in a different context. The doctrine of colorable legislation is a doctrine which applies in the legislative domain, but he is using that argument, and which is legitimate. There's nothing wrong with the extension of legal principle to a cognate field. There's nothing wrong about it, and this is how the argument is built up. So you should be very clear on this argument which is being used, that this is a, there may be a question which talks about the doctrine of colorable use of power. So colorable power, to put it in very basic terms, what I'm not supposed to do directly, I can't do that indirectly also. That is colorable use of power. Now that is whether it is exercise of legislative power, or whether it is exercise of executive power, or it is exercise of power under a subordinate legislation, whatever it may be. If you are going outside your domain, you are in trouble deep. Very simple, constitutionally speaking. And that is what Elon Musk company, that is the petitioner herein, says, that while you are exercising power under section 79, there is a judgment of the Supreme Court in Shreya's single case which mandates that section 79 power has to be read conjointly with section 69 and section 69A. And since you have not done it, therefore the exercise of power which you have made is basically a colorable exercise of power, and hence it needs to be struck down. Do you understand what I'm saying? I'm sure after this much explanation, at least you must have understood what is the basic, where from the argument is coming, where how the argument is framed, and what are the constitutional principles involved in framing of the article, framing of the argument. This is what is the most important thrust of their article, that you can't short circuit 69A, because when you are short circuiting 69A, you are ridding yourself of the procedural fairness which the law contemplates. Under Article 21 of the Constitution, it is stated that all the the state shall, is number 1, that is Article 14. And then the whenever you deny to any the liberty or the life or liberty, then you have to follow the procedure prescribed by law. But you are not following the procedure prescribed by law because you are you are exercising a colorable power under the clock of exercising power under section 79(3)(b. You have basically bypassed the provisions, mandatory provisions under section 69A, and which is also mandated by the judgment of the Supreme Court in Shreya's single case, where the procedure has to be followed. I hope this is clear to all of you. And if you have any doubts, you can still question me. But if you don't have any doubts, you generally don't come forward with them, even if you have. So I will presume that you don't have any doubts, and we can move on to the questions. We can take up the questions now, one after the other. Actually, I have opened so many windows that that my system is having problems in opening that relevant tab. So this is, yes, just give me 1 second. This is switched on to something else. Yes, I think it is question number question number 90, if I'm correct. I hope I'm correct. This is 100% correct. Doctrine of colorable legislation. I have taken so much time in explaining it. It's already know it. At least the question has been replied correctly. Right. Then we come to question number 91. The Union government issues orders under section 79 of the IT Act, informing social media intermediaries about illegal content and warning them of liability if the content is not removed. An intermediary takes a writ objection to the above order. The petitioner argues that they are not liable to comply with the government order, as the same is illegal. You have to take a decision. So 79 is there, intermediary takes a writ objection, then government action is unlawful under section 79. Because this is what we have been discussing for the last 10-15 minutes, that 69A provides the procedure under Article 21, and you can't act in violation of Article 21 as well as the procedure prescribed by law. You have to act in terms of section 69A, because that is the procedure prescribed by law under Article 21 of the Constitution. Therefore, this Action of yours will fall foul of Article 21 of the Constitution. It will fall foul of Section 69A of the Constitution. Right? Then there is another question, which is you people have. This is a landmark judgment, Shreya Singhal says, which was asked. So 93rd is also correct, so I don't need not spend any time on this. 94. Yes, 94 seems to be some problem is there with the kids. I'll just go through it. In 2022, a popular food app, delivery app, Yum Rush, updated its terms of service mandating restaurants to exclusively use its
Sir, it's
platform
new
for digital
passage.
food. Yes, Beta, please repeat once again.
Sir, it's new passage.
It's a new task.
It's a new passage. All right, then please read the passage and tell.
The Competition Commission of India imposed fine on the Meta and banned it sharing the WhatsApp user data and with Facebook and Instagram for 5 years. And Meta challenged its order in the and CLAT. This granted stay on the penalty and data sharing ban on January 23, 2025 on Meta depositing the 50% of fine. And the WhatsApp 2021 privacy policy update forced user to accept the expanded data sharing with Meta platform. This take it or leave it policy give Meta an unfair competitive advantage in the digital advertising. And data is the new oil that it can be collected, analyzed, and reused indefinitely. And tech giant like Meta and Google leverage vast user data to refine the algorithms, target ads, and the lock users into their ecosystem. And the Google was fined for abusing its dominant position in multiple markets. Meta faces a lawsuit over its accusations of Instagram and WhatsApp accused for blocking competitions, and Google was found guilty of the violating the Sharpen Act in the search and advertising market. Australia has taken steps to regulate the digital platform, ensuring the fair competitions and consumer protections. And the Indian Competition Act 2002 focuses on price-based dominance, but digital markets rely on the data aggregations. And Digital Personal Data Protection Act 2020 regulates the data collection with the consent, but lack coordination with CCI. And India should adopt the EU approach, integrating the competition law with Digital Market Act and GDPR. Highlight the India growing effort to regulate the digital monopolies, and stronger law and global best practices are needed to address data exploitation and anti-competitive behavior. And Indian digital economy is evolving rapidly and requiring the forward-thinking regulatory framework and to balance the innovation and fair competition.
So this passage talks about that on November 18, 2024, the Competition Commission of India fined Meta rupees 213 crore approx and banned it for 5 years from sharing WhatsApp user data with other Meta platforms. And Meta appealed, and the National Company Law Appellate Tribunal, uh, they posed the ban and penalty, and they asked Meta to deposit 50% of the fine. And CCI said that Meta misused its strong position by forcing WhatsApp users to share data for advertising, which hurt competition. And in this digital age, data gives tech companies like Meta and Google great power, and they collect huge amounts of user data, and this helps them in dominating market. And uh, i- this also helps them eliminating their rivals. And similar issue have been happened globally, and the US, EU, Australia, and others have taken action against Meta and Google for using their power unfairly. And India fined Google in 2022 for forcing Android users to install its apps, and the CCI orders uh, so that the need to control tech giants better. And India's current Competition Act 2002 uh, doesn't fully handle database power, and the law should be updated to include data monopolies and focus on how data help us big tech dominate, and better coordination between the CCI and the Data Protection Board is also needed. And India can learn from the EU's Digital Market Act and GDPR. And basically, this meta case is a turning point, and India must modernize its laws to manage digital growth fairly and prevent tech monopolies from harming competition and privacy. That's all from my side.
Yes.
This article basically talks about the dominance of digital giants in India and what reforms we need to level the competition. So basically, what this article focuses on is the case of Meta. So Meta was fined 213 crore by the Competition Commission of India, since the commission had recognized that Meta was effectively forcing data sharing across its platform, which was a way to solidify its dominant position. So what now the Indian competition law does not actually state that uh, maluse of data is a illegal practice. However, what the Competition Commission did was that now Meta basically has this take it off lead approach where they would collect user data from WhatsApp or Facebook, and they would use it to amplify their ad targeting power. Now, the CCI found this a very coarse approach since the users couldn't meaningfully opt out, and found this to be violating the Competition Act. Now, even though India lacks this Data Monopoly Act, these CCI still found a way around it by interpreting this approach from Meta as being coercive and therefore illegal, and were able to fine it. However, if you take the case of the European Union, where the European Union had recognized that Meta was uh, basically abusing its dominant position to combine user data without consent. Unlike in India, where they had to find a way around the entire and interpret it differently, the EU didn't need to make a very distinct interpretation. They just straight up said what the problem was, that Meta was abusing its dominant position in the retail market. So this basically signifies that India lacks a proper data monopoly and uh, uh, data sharing law, because of which many practices simply cannot be uh, fined by the Competition Commission as being unlawful. And says that we must take reforms from the example of the European Union. Now, in the case of US and Australia, similar uh, Google and Meta are facing similar lawsuits, such as the Sherman Act in the US and the Platform Regulation Act in Australia and other countries. The article also talks about how dominance is not equivalent to price, since while the dominance of a platform may be high or low, the now basically in classical monopolies, as dominant companies become more uh, when companies become more dominant in markets, their uh, monopolies end up raising prices of certain goods, whatever the monopoly is of. However, in digital monopolies, the company that's in monopolization of the sector in question is able to make things cheaper and get a much more bigger user base by capturing user data and using it to target similar users. And that because the more users are connected to other users, such companies are able to grow much bigger as they grow, are able to grow at a much more rapid pace than what a classical monopoly would be at. And so in classical monopolies, monopoly acts are simply not capable of handling digital monopolies because of the very different nature they have. And that's really the core of the article.
Yes. 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 So, in this case, very interesting. Antitrust is the terminology they use in the US for anti-competition acts. The Competition Commission Act is called the Antitrust Act in the United States, the Sherman Act, right? So, what is all this about? The controversy has basically erupted with respect to certain actions on privacy policies that have been taken by the the conflicting sides, that is the Competition Commission and um, the regulated bodies such as WhatsApp, Meta, and all these. So how the controversy has arisen? Because there was a change in the um, uh, privacy policies, whereby the whereby the data of the user was shared with the affiliate company. What difference does it make? Why it should be an issue? You are sharing your data in any case when you are agreeing to use that system. Then certain cookies are being downloaded on your system or into your mobile. You have in any case parted with your data. So much of your data is already there with them. So what is the fuss all about? The fuss is what use you put this data to. That is where the problem comes in. Now, what is the problem? How do you use the data? You use this data to refine your algorithms. What do you mean by that? Refine your algorithms. Sounds very interesting. Sounds very fashionable. But what does it mean? Basically, what it means is you must have noticed that Google, whenever you do a Google search, you'll get some answer, right? So Google search gives you certain answer, and Google search, how is it able to give the answer? Because of data. Why Google search has become the most popular search engine in the world? Because what Google does is the vast amount of data that it has accumulated. With that data, it it develops its algorithms of the search. What do you mean by that? Algorithms of the search. What is meant is, suppose you have put something in Google, it has become so popular that we, in our ordinary parlance, we say that, oh, you don't understand this, put it in Google. So we say all this, we talk like that. You put it in Google, you Google it. So why Google it? Because of the network effects, that is the large population of users that Google has uh, visiting its search engine. What happens is, when somebody has searched something and the frequency with which that has been done, the algorithms will bring those searches first. So whatever you are searching, somebody else must have searched before you, and somebody might have searched before you in more direct or in more relevant terms. So that comes as a pop-up when you are typing. There will be a drop-down list of around 10 searches which are the same as your searches. and you can choose one of them, which restates your problem for which you are doing the research in a better way. So why is this happening? This is that algorithm that he's talking about. This is when you have large number of users, when you have large number of people coming to you doing research, and many times, and most of the times, that somebody might have already searched what you are searching, and Google is able to bring that because of the large network that it has, the network effects they call it, and because of that, the Google search engine will take a fraction of a second, which the other search engines like that of Microsoft, or the search engine like that of Yahoo, or some other search engines, which have also, some of which have also been acquired by Google, you know, and that is what this antitrust is about. So you have a vast data pool from which the searches will be faster. Once the searches are faster, then people will come to you, they will not go to another search engine. And that is exactly what is creating the problem, because then when that kind of thing happens, then there is no barrier for there is a barrier that is erected for entry. Other companies can't come and provide the similar services because 90% users prefer Google. Now that creates a problem for the persons who are who want to launch their own services, or the existing platforms which are providing similar services. And once that kind of monopoly comes in, then what is the problem? After all, the customer is getting customized searches in a short span of time in a most efficient manner. What is the problem? The problem is here. Google searches are free, not because Google is doing a charity on people, because their searches are free so that they can popularize their search engine, so that their search engine is able to return better better informed choices in the drop down menu, as well as takes less time in delivering the search output. And if these two things are taken care, then people will have, as they have already done, people will shift in mass numbers to Google. Then this has already happened. This has already happened. You Google is not being doing charity merely because the searches are free. Searches are free because it serves their purpose. It serves their purpose because it reduces the search time, because it gives them advantage of the network effects, the large number of users who are keying in the same kind of problem, and instantly the result will come to you, and result will come to you in ways in which you can't even imagine. That kind of result will come to you. Now let us go to the next step. What is the next step? How does it create a problem for others? It creates barriers. It creates barriers to those who want to expand, and barriers to those who want to enter, because there is a monopoly that is existing in the market. And once the monopoly comes in, then the consumer is taken for a ride. That is what is the teachings of the competition law. That is what is the teachings of the antitrust law. That never allow any corporate actions which will undermine competition in the market. There must be fair competition. The giants, or for that matter, even non-giants, are controlled economically only and only when you have symmetry in the markets. Markets should be fair. Markets, at any given point in time, there should be a number of competing firms which should be providing the services, so that there is a healthy competition amongst them. So that is what is the philosophy behind the Consumer Protection Act. Now, what is, I go to the next step. How has the advent of AI impacted the Google searches? It will definitely impact Google searches, because nowadays people don't even go to Google. People go to the AI, to the Copilot, to the Chat GPT, to the Gemini, to the Bard. To these people go. Why do they go? Because they do the search also for you. They take it to a very great. That is very. You have a search engine in Google, but here you have a search engine who actually searches for you. In the search engine, you have to do the search, but in AI, the search engine will do the search for you. So they have changed the rules of the game altogether. So as there was a newspaper article when recently that as of now the Google's dominance has not been questioned, but it's only a question of time when the Google's all this becomes irrelevant. Once once the Copilot, ChatGPT, and all these these penetrate into the market and take a market share from Google, then this entire battle might become irrelevant. Then we will have to focus our lens on the doings of these new giants which are emerging, and which are gaining the market share day and night. They are working into this. Now I having explained how this works, how it creates entry barriers. There are entry barriers because all subscribers have mass shifted to Google. Now just imagine a situation when the data of several Google companies is populated and given to Google from various different sources. It is coming, and in the privacy policies, when you join WhatsApp, when you join Instagram, or so you join some other social media platform or some other online platform which is in for which these companies are competing against each other. The Google, Yahoo, Rediff, and all those companies which are competing now, they have all lost to Google. Even Microsoft, this thing, that is the binge, Microsoft Word's binge, all of them have lost to Google. Now just imagine what will happen when all the affiliate organizations of Google are providing their data to Google. Now there will be a storm in the market, that the whole market, 95%, 99%, 100% has been taken over by Google. That will be a very sorry state of affairs for the consumer. They don't realize that this herd mentality will basically turn around and bite them very hard, because then Google will be able to charge monopolistic prices, just like it happens when a new drug is entered, new drug enters into the market and is enjoys copyright or that patent protection. The prices charged are maybe something like 10 times the prices which are charged of compared to comparable of patent drugs. So those kind of things, the Sherman Act, the Antitrust Act, the Antitrust laws, and the Competition Commission of India Competition Act, those are the situations which the law is intended to avoid. The cartel building, the rigging of public procurement contracts and all that by formation of cartels among the suppliers, among the vendor suppliers. So all those situations are sought to be prevented by the Competition Commission of India Act, the Competition Act. And I will take you straight to section 3. So I'll go here and I'll make it a little bigger. I hope this is a little bigger for you also. Now, you see, what are anti-competitive agreements? No enterprise or association of enterprises or persons or association of persons shall enter into any agreement in respect of production, supply, distribution, storage, acquisition, control, or provision of services which causes or is likely to cause an appreciable adverse effect on competition. So that is the crux of the whole thing. The whole debate is around this, that there must not be an appreciable adverse effect on competition, and for that no agreement shall be lawful if that appreciable adverse impact on competition takes place. This is what Article 33, Clause 1 of the Anti-Competitive Agreement. Any agreement entered into contravention of the provision shall be void. So this is the importance the law attaches to competition. Promotion of healthy competition among the market participants is the only solution to monopolistic tendencies, where the consumers are not given the best price and the most efficient service at the best price. So this is the concern of the Competition Commission Act. Now, what is the consequence? Apart from the agreement is being rendered void, now just see clause 3 what it says. Any agreement entered between enterprises or association of enterprises. Now, or between persons and enterprise or practice carried on or decision taken by any association, right, of enterprise or association of persons, including cartels, engaged in identical or similar trade of goods or provisions of services, which directly or indirectly determines purchase or sale prices. So you see, cartel building means 4 or 5 people come together and they said, we will charge this much, and everybody is going to charge this much. That is cartel, price cartel. All right. Now then he says limits or controls production supply. We will produce only this much in order to keep the prices high. There are a few competing firms in the market. They produce only this much. When there is a supply side constraint, then the demand is always going to keep high, and when the demand is going to keep high, we can dictate prices to the market. That is what is the policy. Shares the market or source of production or provision of services by way of allocation or geographical. So split up the market and tell that Tata Steel is going to operate in this market, Bhushan Steel is going to operate in this market, and another steel company is operating in that market. And we are charging the same rates across all the markets. So this is cartel building. This is splitting the market amongst yourselves. All these happen in the corporate. That is why the law directly or indirectly results in bid rigging, collusive bidding. So to have an appreciable adverse effect on competition. All right. So appreciable adverse effect on competition is struck down, is frowned upon by the law in India, by the law in the US, by the law in all the jurisdictions which have competition policies. And the whole idea is the public interest in keeping the fair competition, introducing fair competition into the market. If the fair competition is not there in the market, then the consumers will be taken for a ride. The economy is going to suffer, and there will be some firms which will be super rich, and there will be at the cost of other firms, which will not end at the cost of consumers, which will not be a wise allocation of resources as ordained in Part 4 of the Constitution, the directive principles of the state policy, which are saying that communities' resources should be so distributed so as to subserve the common good. So what are they talking about? They are talking about John Rawls distributional justice, that the consumer should not be taken for a ride. The consumer's interest must be protected. The consumer's interest must be upheld, and that is what the Competition Act talks about by talking about appreciable adverse impact on the market. I hope this is clear to you. And since I know you will not reply to my poser, so I'll straight away proceed to the questions which you have marked incorrect. So the first one is question number 93rd. All of you have marked correct, so I'm very happy about it. Then there is question number 94. This you have not marked correct, and this is actually the provisions of competition law. I need not explain them further. I have already dealt with them at length. And basically what it is saying is that the Yamrush updated its terms of service mandating restaurants to exclusively use its platform for digital food services. This exclusivity clause required restaurants to cancel partnerships with other delivery platforms. Yamrush justified this by claiming it would streamline operations and provide better customer service. The requirement left restaurants with little choice but to comply due to Yamrush arguing. You did not tell me that I am not sharing the appropriate this thing. Regulatory authorities initiated an investigation arguing that Yamrush exclusivity clause might constitute an abuse of dominant position. So when you are talking about abuse of dominant position, you are basically talking about the competition law of India. Where is it written in the competition law of India? The abuse of market position. Can you show it to me as to where it is? I'm showing the this thing. Where is it written in this? This is section 4. He is talking about abuse of dominant position. No enterprise or group shall abuse his dominant position. There shall be an abuse of dominant position if an enterprise directly or indirectly imposes unfair or discriminatory condition of purchase or sale of goods, price in purchase sale, including predatory price of goods or services. So limits or restricts production of goods, indulges in practices resulting in denial of market access, makes conclusion of contracts subject to acceptance by other party of supplementary obligations by their very nature have no connection with the subject of such contracts, uses its dominant position in one relevant market to enter into other relevant market. So these are basically dominant position means a position of strength enjoyed by an enterprise in a relevant market, operate independently of competitive forces prevailing in a. Now, if the firm is so strong that it can just disregard the competition from other firms, then consumers have a massive problem. Then there's a problem of public policy. There's a problem of public interest. Immediately that will arise. So this will be hit by the Competition Commission of India. I hope this is amply clear to you. This is This is held by the Competition Commission Act, and therefore this is option B. That is the 2 is the correct answer. Then I need not got into this because 100% correct. Meta, this I will not go into. This I will not go into because issue landmark order. That's all right. So I hope the legal section, I think we have covered the legal section fully, and I hope to the entire satisfaction of everyone. And if there are any problems, if you don't understand or if you think that I was a little too fast, then you can refer to the recordings once again. The recordings are always shared with you. I have shared the folders accessibility with you. So anytime you can see the recordings of any section. The same applies to mathematical, the quantitative part also. The recordings will be available to you. Wherever you have a doubt in your mind, you can visit the recordings. Unfortunately, the recording has for mathematics has been started from today because things have started getting streamlined from today only. Today only we have started activated the digital board because the stylus arrived. It took almost 1 month for the stylus to arrive, and everybody was sending congratulatory messages that finally you have got your stylus for which you have been asking since April. So that is also a landmark achievement for us that we got the stylus, and visibility improves immediately. There is a lot of difference in the visibility which was there when we started it, and the visibility since we adopted the digital board. Anyway, I have gone on and on. We have been sitting for a long time. Now let us call it quits and see you tomorrow with the logical reasoning questions tomorrow, right?
If you intend to join us in our daily discussions, you are most welcome.